Welcome to Medmarc's webinar series. I'm Kate Klaus, Senior Attorney in Medmarc's Risk Management Department. Today's presentation is titled 2021, Another Year Unlike Any Other. On behalf of Medmarc and today's presenters, thank you for joining us. And with that, I am pleased to turn things over to my colleague, Claims Examiner Scott Lazzaro, who will begin today's presentation.
Thank you. As Kate said, I'm Scott Lazzaro. I'm a claims examiner with Medmarc's Claims Department. And on behalf of today's panelists, thank you for joining us. I'm going to begin today with reviewing the agenda. We will first cover COVID's continuing impact upon our industry, follow that up with some updates on some mass torts, 2021 significant verdicts and decisions, regulatory updates, and finally, what we will be talking about next year. Today's presenters are Megan Grossman, Karen Shimonsky, Lauren Hulbert, Andy Hall, and myself, Scott Lazzaro. Megan is a partner with the Philadelphia office of Louis Brisbois and vice chair of the life sciences practice. Megan is a trial attorney representing companies in general liability, products liability, and complex litigation matters. Karen is a partner at the Denver office of Gordon Rees and is a member of the Healthcare Professional Liability Defense and Appellate Practices groups. In addition to healthcare matters, Karen handles product liability cases, complex business disputes, general professional malpractice, including representing clients in administrative board matters, and a variety of diverse issues depending upon her client's needs. Lauren is a senior claims examiner with Medmarc. She joined Medmarc in August of 2005. Lauren has a wealth of experience, and due to her varied experience, she has handled claims in increasing complexity and severity over the course of her time here at Medmarc. Andy joined Medmarc in 2017 as a senior claims examiner. Andy, in addition to his normal responsibilities as a claims examiner, also works on product development team, where he assists with drafting language for our new products. And finally, I joined Medmarc in September of 2019 as a claims examiner, and as well, in addition to my normal responsibilities, I bring to the company my experience after over 16 years in the automobile industry, adjusting high volume bodily injury and property damage claims, and focusing on staff development and organizational continuous improvement. With that, I will be happy to go ahead and turn things over to our first presenter, Karen Shimonsky, to begin the discussion on COVID's continuing impact and the PrEP Act and other related issues. Karen?
Good afternoon, everybody. I have the pleasure of talking about some kind of more dry topic for today. I know that the PrEP Act is something that is important to all of us and impacts all of us, and has been kind of ever changing over the last 2 years. So I'm just going to briefly kind of give everybody an update in the last 6 months, and we do have some significant updates, and we're starting to get a little bit more clarity from the courts on exactly the breadth and scope of the PrEP Act. So before we move into kind of the case law update, I know that most of us are probably generally aware of what the PrEP Act is, but just as a general background and refresher, because it has been ever changing, the PrEP Act is the Public Readiness and Emergency Preparedness Act. It was enacted in 2005. The way it works is it lies dormant until the Secretary of Health and Human Services invokes it. And that was invoked with COVID-19 in March of 2020. And what it does is it provides immunity as defined by the Secretary of the Health and Human Services. So it provides immunity to covered persons, which kind of for our purposes applies to pharmaceutical companies, manufacturers of drugs, devices, products. And it provides that immunity related to products or drugs or devices that are used to treat, diagnose, cure, prevent, mitigate COVID-19. So once this was enacted, there had been, litigation and trying to get some clarity and updates by the Secretary of Health and Human Services on who a covered person is or what a covered countermeasure is. Up to this point, that's been, clearly defined by the statute and by some, amended declarations by the Secretary and updated advisory opinions. But what really kind of the last 6 months that we've seen is the court's trying to make sense of just kind of who exactly is entitled to this immunity and what they're entitled to it for, which types of claims they're entitled to it for. The act, by its plain language, says that immunity is going to extend to the covered persons, making them immune from suit and liability, whether it's state or federal. But the one exception being that claimants still have, pursuant to the statute, a claim against a covered person related to a COVID-19 covered countermeasure for willful misconduct. That's gotten us kind of up to this point. That's been clear that there still is exclusive federal jurisdiction, meaning a claimant can file a lawsuit in federal court for claims of willful misconduct. But other than that, immunity is clearly extends to those covered persons, those manufacturers for covered countermeasures, things relating to COVID-19. And willful misconduct, up to this point, had kind of been defined as the statute as something that is more stringent than negligence or recklessness. So the developments we saw on this slide, the noteworthy guidance that we've gotten from the federal appellate courts came in October in the Magoli v. Alliance Healthcare Holdings case. As to up to this point, and arguably this still has not been totally cleared up, but there was a split among the federal courts as to whether this PrEP Act statute was a complete preemption statute. Meaning, does this statute totally trump all state law claims, even if someone is not quite falling in the clear covered person or the related to the covered countermeasure? So a lot of the nursing home facilities in the last 6 months have been trying their hand at trying to get their state negligence claims removed to federal court, claiming that they're not clearly outlined perhaps as somebody who is a covered counterperson. Their claims are not administering covered countermeasures. Instead, it's most of the claims against them are that they failed to prevent infection to the elderly. And they're arguing, well, the PrEP Act totally fills the space and there's no removal attaches to anybody, not just within the confines of this. So Magoli says, the statute says that the only potential claim that can ever be brought in federal court, even against the device manufacturers for COVID-19 drug-related administration, are willful misconduct claims. So this case says that this is not a complete preemption statute, but rather perhaps willful misconduct claims, the PrEP Act may preempt willful misconduct claims if a plaintiff's attorney were to file that in a state law court. And the only other potential claims that could be preempted would be ones that would be within the scope of that specific willful misconduct claim. So this Magoli case really, for the purposes of the life sciences industry, not a huge impact or change because state and federal law claims will still be preempted as they pertain to those clearly defined by the statute. But it does start to give more guidance, which may impact the life science industry on what willful misconduct is and what for those companies or individuals who are not clearly falling within the covered person's scope or definition within the statute, those that are, or perhaps it's things like failing to administer types of covered countermeasures versus the other ones that are clearly defined in the statute. This may have an impact on the life sciences industry because it starts to define or reiterates willful misconduct is the only claim that can exist in federal court at all. That's the only one that is getting around immunity, and it's something more than negligence and recklessness. Something else that Magoli comments on, and I'll talk about this a little more in a second, is what sort of deference the courts need to be giving to the amended declarations of the Secretary of the Health and Human Services, who has done several amended declarations and several advisory opinions trying to define that this is a complete preemption statute, who the Secretary has defined that nursing homes are in fact intended to be covered counter persons under certain circumstances. And the Magoli court says, no, we do not have to give deference to the declarations or advisory opinions because we're not even sure the Department of Health and Human Services has any authority to do anything to tweak the statute. They can just say the statute's in effect. So the next slide, please, is just, a brief kind of touch on the more recent claims, or the more recent cases. One is a couple days ago. These are the district court cases that are taking Magoli, and again, in the context of the nursing homes, so not in the life science industry realm, but now kind of trying to tweak, well, what is a willful misconduct claim? If the option exists that a willful misconduct claim that's brought against a nursing home may be one that is only rightfully brought in the federal courts, does a punitive damage claim count as that one? When that is pled in a state court claim. The recent guidance that these district courts can just kind of see what they're starting to do. Punitive damage claims in Eastern District of Pennsylvania not meeting willful misconduct. The Central District of California calling the claim of willful misconduct. Just because you say that's what your claim is, that's not enough. Your allegations actually have to be akin to recklessness. The other little recent guidance we got was there's been a couple comments from a couple district courts that the proper procedure, if the PrEP Act is not, if the claim is not brought under the PrEP Act, if it's a state negligence claim and the defendant wants to say, no, this should be brought under the PrEP Act, the proper procedure, and this was according to a California district court as well, it may be to raise it as a motion to dismiss versus just removal. That is so unclear. I would, until there's more clarity on that, I would continue, especially when it is a life science claim with a covered countermeasure, removal is probably the most appropriate. Next slide, please. These are just pointing out other courts are now agreeing with Magoli since the Magoli opinion about the what weight the Health and Human Services declaration, the amended declarations, which I believe there have been 9 thus far. Again, trying to amend what scope is intended by the PrEP Act and advisory opinions. They're just, the courts are uniformly right now saying these are not entitled to deference. They're not persuasive. They don't have to follow them because there's been a lot of clarification by the secretary as to what a program planner is or what scope is covered. Next slide, please. This map right here is, I wanted to just kind of give you all a visual of state COVID immunity statutes that have been enacted and are currently pending. You can see there are a lot of states that have passed legislation in some sort. There's a great resource that will circulate, or I think she put in the chat is, there's a database where everybody can kind of go and keep up with what's been enacted, what's pending, and what's being struck down. The only little kind of, I guess, tweaking to this is Missouri has passed they had pending legislation as of a few months ago, and that's been passed recently. And you can see that you can see in here where the majority of the states are enacting these COVID liability shields in some way, but Some are more narrow, some are more broad. So I encourage everybody to look into what their state's doing and what's passing in their states right now.
Thank you very much, Karen. At this point in time, I'd like to turn it over to Megan and Lauren to continue talking about COVID's impact on it, how it's impacting our courts and litigation.
Thanks, Scott. Go ahead and move to the next slide. So everybody, this is a quick review of kind of what we thought last year and what was going on last year in 2020 when we were in the middle of staying at home. So there have been a lot of changes since then. There have been a lot of positive effects that have kind of happened in 2020 and 2021. We did think that in 2020, the global market was going to decrease. It did. The articles indicate that it's at about 4% of a decrease. However, in 2021, the global medical device market has expanded 6% and is expected to continue to grow until at least 2029. Similarly, in 2020, supply chain shortages continued to be a challenge in 2021, from global semiconductor shortages to shortages in aluminum and other raw materials. Much of the life sciences medical device industry was challenged by some sort of disruption in those supply chains. And this is unfortunately expected to continue until through 2022. The market has also, COVID-19 has also caused the market to utilize new technologies sooner than anticipated. Included in that would be telehealth organizations. The utilization of telehealth and telemedicine has increased by about 26% over the past year due to the effects of COVID. And then in addition to all of those changes, there have been additional products brought to market and changes to products that have existed prior in order to allow for those devices to be sold and used in home for patients. So next slide. So specific to Medmarc, there have been a lot of different changes. I'm sure every single insurance industry subset has had effects due to COVID. They used to, last year we had discussions and it was anticipated that, cases were going to be able to resolve earlier and sooner because cases would be able to have a discount just due to the extended litigation that was expected and the delays from the courts and different things. While that may be true in some sectors based off the information that we have and what we've collected over the past year, specific to Medmarc, we haven't really seen that kind of effect on new claims by people staying at home or by those elongated life of claims. Okay, next slide. Oh, and I didn't change mine. So this is the same kind of thing. It again, just kind of reiterates from Medmarc's standpoint, these are closed claims. Where we are, claims haven't necessarily, the life of claims hasn't necessarily shortened or elongated just because of the pandemic as specific to Medmarc. And Megan, I think the next section is yours.
Yes, thanks, Lauren. Hi, everyone. This is Megan. In looking for information and resources related to COVID and how it's affecting litigation in the courts, I found this COVID coverage litigation tracker, which is actually managed by UPenn Law School and a company called Insurance Law Analytics. And I think it's interesting because this particular this particular tracker has data on it related to weekly filings, related to coverage cases that relate to COVID, They have information about merits rulings on motions to dismiss, the allegations that are sought in those particular cases, for instance, the coverage that's being sought by the insureds for business income, extra expense, et cetera. It also provides information if there's class allegations or bad faith allegations that are alleged in those lawsuits. And it provides a listing of the different insurance groups and the number of cases that have been filed for coverage cases against those particular insurance groups, as well as the most frequent industries. And as you can imagine, the most frequent industries that's found in this coverage litigation tracker are food services and drinking places. As it relates to Medmarc or people who are attending this webinar, there are also ambulatory health care services on there. There are hospitals, and there are also some manufacturing industries that are listed within this tracker. So it's constantly being updated and it's being managed by UPenn. So I thought it would be a good resource for people who might want to look up the status of coverage cases related to COVID. You can go to the next slide, please, Scott. As far as the impacts of COVID on litigation and how it relates now from in 2021, I'm going to give the worst answer that people hate when you do things like this, but it depends. It varies from state to state. It sometimes even varies from judge to judge within the different venues and jurisdictions of whether the courts are actually reopened, whether they're having in-person hearings, whether they're having in-person conferences. I will say from my own personal experience, I would say about 95% of my judges continue to hold conferences, hearings remotely. The one major lawsuit that I'm involved in the ValsartanMDL for the very first time at the beginning of December 2021. Judge Rosenberg, actually held an in-person science day. It was a full day conference where they talked about the science related to the claims in the ValsartanMDL. And that was the first in-person conference that was held. However, the judge asked that only people who, only necessary people actually come, because again, there's limited space in the courtroom and they had to make sure that they were following the CDC guidelines about distancing. So I do really think that it depends from court to court, judge to judge, how they're handling their conferences and hearings. However, I did find that there's a website or a link that's provided that for federal court orders and updates that show all the orders that have been entered by certain of the federal courts, and if there's any specific updates that are available on the court website. I think for each individual court, you just have to obviously look at their own website to find out what the status of the reopenings are. As far as virtual hearings and trials, I know at the beginning of the pandemic, especially in 2020, more so than 2021, it was a big concern about whether there were going to be trials that were going to be able to be handled. I do believe that many courts within 2021 have once again begun having trials. Of course, it's difficult to have the trials going forward because of all of the restrictions, having to restrict the number of people who are able to attend the trial, making sure that they're following the CDC guidelines. But as 2021 has progressed, that seems to be increasing, and the courts obviously have had some practice over the last 2 years to be able to adapt. I personally haven't had any of my cases set for trial. I think that all the trial schedules in every court that I'm involved in are so backed up due to 2020, that everyone's trial schedule has been pushed to a later date in order to help with that backlog of cases. Lastly, I had a little topic here about attorney adaptation techniques. And what I wanted to cover here was, I know at the beginning of 2020, none of us knew how to constantly be on Zooms and constantly be on WebExes. And one of the things that I have found that has been helpful over this time period is learning how to take depositions and attend depositions via Zoom, via video conferencing, and being able to use exhibits over the platforms or the software that is being used by the court reporters. I remember a time when if you were attending a deposition remotely, you had to send your exhibits in a sealed envelope to the witness and or to the opposing counsel that they opened right then when the deposition was starting if you weren't able to be in the room with them. But at this point, there's so many different platforms and vendors that are able to assist in a way to be able to utilize the exhibits that you can just put up on the screen and or the witness is able to manipulate on the screen. So that is one thing that I have noticed has changed, especially over this year. It's almost commonplace at this point. And I'm so much more used to being on video depositions and video conferencing depositions as opposed to being in any depositions in person at this point. Some other adaptation techniques is even attending hearings with judges is making sure that you're very prepared, but you're also very professional. I think we've all seen the funny video of the gentleman who got onto his Zoom and he looked like a cat, I think it was. And I think at this point now, we are all used to having to be on Zooms or video conferences in front of the judges, but you have to make sure that you're doing it in a professional manner and that you're not doing anything that could make the judge angry with you. Being prepared, being on time, still looking professional, at least from the chest up, if you're going to be on camera, and making sure that you're following all the same rules that you would if you were in the courtroom with the judge. You can go to the next slide, which I think is Lauren's slide. Thank you.
Yeah, so after looking at all of the impacts that Megan has outlined for us, as well as what we've experienced in handling claims, this slide is just meant to kind of review what are we getting out of that, right? So we have the short-term effects and then the long-term effects of COVID and what that does on our claims and litigation, and ultimately what it does on our risk exposure and our expenses. So much like court openings and what judges are doing, unfortunately, the answer is kind of, it depends on what is going on and who, what the judge is allowing, and if you can be in person or remote. But ultimately, if you're attending if you're doing virtual depo preps or depositions, court hearings and conferences and trials, then there is some short-term expense savings given the lack of travel and attorney time than traveling for those things. So at least in the short term, this spend on an annual basis could be less. The opposite side of that is, if everything continues to get delayed, then you still are going to have people reviewing and learning and incurring those similar defense expenses for a longer period of time. And so it's anticipated that possible overall litigation costs will likely increase.
Thank you both very much. And I believe at this time, Megan is going to rejoin us to discuss some updates to mass torts.
Yes, thank you. As everyone knows, there's obviously a lot of different types of mass torts that are currently pending in the United States for 2021, but we wanted to cover a couple that might be of interest to individuals who are on this particular webinar. So first mass tort that we wanted to cover and give a little bit of background information about is NDMA or NDEA contamination litigations. And NDMA is an N-nitrosamine, and it is a known carcinogen in laboratory animals. And so there are numerous lawsuits that are pending that relate to alleged NDMA contamination in certain pharmaceutical products. And a few of them are, and the most well-known ones are, first, the In re Zantac ranitidine products liability litigation, which is pending in the Southern District of Florida. And as I just noted, recently, it's before Judge Robin Rosenberg down in the Southern District of Florida. This particular litigation basically involves claims that the Zantac and or ranitidine ended up in having NDMA contamination, mostly due to storage, transportation, degradation issues that relate to Zantac or ranitidine. In other words, the plaintiffs are claiming that as the Zantac or the ranitidine breaks down, NDMA forms. And they claim that the manufacturers knew or should have known that with having the product in heat or humid areas, that the degradation can occur, and therefore that's why they filed the lawsuits. There are 3 master complaints that have been filed. It's a personal injury complaint, there is a medical monitoring complaint, and there's an economic loss consumer class action complaint. And in this particular MDL, which is the first time that I've ever been in an MDL that does this, and I'm not sure if it's in any other MDLs, but there's a census registry that was set up. So in short, the census registry is a way for plaintiffs to be able to place their potential clients into a registry without actually filing a lawsuit. It's a way for them to place a claimant in the registry, toll the statute of limitations while they conduct their investigation to see if the plaintiff actually has developed any of the at-issue cancers that are being alleged in these cases, or if, so they can do investigation to find out what particular products the claimant might have taken, whether they took the brand, whether they took generics, whether they took over-the-counter, or they took prescription, and trying to decide whether they're going to pursue the claims. I think as of the last time I had any definite information in the census registry for Zantac, there's approximately 150,000 claimants that are currently sitting in the census registry. And there's discussions ongoing about how that's going to be either cleared out or how those claims will progress, but for the time being, they're just sitting in the census registry. The generic defendants filed motions to dismiss, and in, I believe it was July of this year, they were granted and on preemption grounds, and all of the generic defendants were dismissed from the MDL. There are currently appeals that are pending in the 11th Circuit related to the generics being dismissed. And there are also some of the plaintiffs' counsel who have started to file state court personal injury cases in certain areas like Madison County, Illinois, and Philadelphia County. If they don't like the result, obviously, that has occurred in the MDL. So they've decided to start filing them in some of the state courts around the country. The focus on the Zantac litigation is on general causation discovery. They're in the process of developing a plan and timing as it relates to expert designations and Hulbert motions. And they're also in the process of developing a bellwether trial selection protocol for the Zantac ranitidine litigation. But as of right now, the brand manufacturers are the main defendants that are left in that litigation, because the pharmacies and wholesalers, along with the generics, were dismissed on motions to dismiss. Scott, if you can go to the next slide. Similarly, there's a valsartan, losartan, and irbesartan MDL that also relates to NDMA issues, or we like to call it, those of us who are in it call it just the sartans MDL. Right now, the focus in the valsartan MDL is valsartan because that was the first medication that was at issue when the MDL was established, and later on, the JPML agreed to include losartan and irbesartan products in the litigation as well. But right now, the focus is valsartan, and this particular MDL is pending in the District of New Jersey before Judge Robert Kugler. Similarly to the Zantac litigation, there are 3 master complaints: personal injury, medical monitoring, and economic loss. But unlike the Zantac litigation, there was a general denial of all of the motions to dismiss, and specifically as it relates to generics and pharmacies and wholesalers, the preemption motions were all denied, which was disappointing because the opinions were coming out at around the same time in both the Zantac litigation and the valsartan litigation, and the rulings were definitely different in those two. Much like the Zantac litigation, there's also a focus on general causation discovery and general causation issues. In valsartan, they're further along in that process, and general causation experts have all been disclosed. They have all been deposed or nearly all deposed, and the initial round of Daubert motions have been filed in the valsartan litigation. They're currently working on replies that will be filed soon. And the belief is that there will be hearings related to those motions in the spring of 2022. Also recently, Plaintiffs' Counsel filed their class certification briefs. And there's obviously the defendants are working on responding to those class certification briefs. As it relates to losartan and irbesartan, master complaints have been filed for those particular medications, and short form complaints continue to come in, but there hasn't been any discovery related to losartan or irbesartan that has been taken yet. And there hasn't been any specific deadlines that have been set for those 2 medications, only valsartan at this time. In valsartan, unlike Zantac, most of the claims relate to manufacturing difficulties or manufacturing issues which resulted in NDMA contamination. There are claims that for some of the manufacturers that it relates to the active pharmaceutical ingredient, the API, that it contained elevated levels of NDMA. And for other defendants, it relates to their manufacturing process in itself, that NDMA is a result of the manufacturing process, not similar to, that's not how it is being alleged in the Zantac litigation. You can go to the next slide. And another, but much smaller offshoot of this is there is an in re metformin marketing and sales practices litigation, which is coordinated in the United States District Court for New Jersey. It is not an MDL. It is just a coordinated proceeding, as the initial filings were all economic loss, like consumer class action complaints, which were consolidated into one master complaint. And it's pending before Judge Arleo in the District of New Jersey. That is currently also in its pleading stage. There is a motion to dismiss that was filed by all the defendants that's pending before the court. This is the second round of motions to dismiss. The original motions to dismiss were granted, stating that the plaintiffs had not established standing to assert the lawsuits in their initial complaint, but they were given leave to file an amended complaint, which was filed, and the motions to dismiss are pending. No discovery has been occurring yet in the metformin litigation. There are a few sparse personal injury cases related to metformin that are being filed in state courts around the country, but those are very few and far between. And for those of us in the litigation, we're hoping it stays that way. And then I just put a little bullet point there about other related litigations. As I said, there are some state court personal injury cases that are being filed in all of the litigations, actually. In Zantac, like I said, they were doing it because they're unhappy with the motion to dismiss ruling in the MDL. But also in Valsartan, there are some plaintiffs' attorneys who have decided to file state court actions, and same thing with metformin. I also was involved in a Prop 65, a Proposition 65 in California case as it relates to Zantac, which is currently up on appeal. So there are some law firms and attorneys who are moving forward with lawsuits related to that. And then there are also some attorney general cases that have been initiated specifically related to these litigations and some of the other pharmaceutical and medical device litigations. I know specifically New Mexico, the Attorney General in New Mexico has begun filing actions against many different pharmaceutical and medical device companies. And there are several litigations. There are several of those cases pending out in New Mexico. You might want to take a look at the New Mexico Attorney General's website to see if any of your clients are implicated in any of those cases. You can go to the next slide. I'm not going to spend a lot of time here. I just wanted to mention some of the litigations that are currently pending related to pharmaceuticals and medical devices. Whenever I want to see what the new and hot thing is, I go to all my favorite plaintiffs' attorneys' websites like drugwatch.com or baddrugs.com. And if you go to any of those websites, you can see the litigations that they are pursuing and what are the popular ones right now. I did want to just mention two of these litigations, and then I'll let us move on to the next slide because I know we're running out of time. The Elmiron litigation, that's an MDL that's pending in the District of New Jersey also. Elmiron's a weak blood thinner that's used to treat bladder pain, and it's alleged to have caused vision problems. And that is pending before Judge Martinotti in the District of New Jersey. I noticed when I was looking on the District of New Jersey website that there's numerous MDLs that are now currently pending in the District of New Jersey. It's becoming the place for MDLs to pend these days. There's Invokana, Plavix, proton pump inhibitors, Elmiron, Valsartan, talc, breast implants. Those are all some MDLs that are pending in the District of New Jersey. As far as medical devices, I listed some popular in quotes, medical device cases or litigations that are occurring right now. CPAP machines, I think we've seen how those are starting to spring up. Paragard, hernia mesh has always been around, and hip replacements. And as far as IVC filters are concerned, just to give a little update or some information about that, there are four different manufacturers litigations that are prominent in this area. There's Bard, Cook, Cordis, and then there's Rex and Argon, and I'm actually involved in Rex and Argon. So I'm going to stay away from talking too much about them, but in general, Bard is one that's been in the news because Bard had the most lawsuits that were filed against it because I believe they have the largest market share. In 2021, there were about 5 trials that occurred for Bard. And there were, by my last review of the data, there was 2 plaintiffs' verdicts, one that was $3.3 million. There was another one that was $386,250, which even though that's a plaintiff's verdict, that's a pretty good result for the defendant as well. And then there were actually 3 defense verdicts for Bard in 2021, one in Florida in July, one in Michigan in July, and one in California in August of 2021. I'm not aware of any other IVC filter lawsuits that actually went to trial in 2021, but those were the big ones that you could find about. And one last thing I just wanted to mention that would probably be of interest to a lot of people here on this webinar is in a Bard IVC filter case. It's called Ebert versus Bard. There is currently an appeal that is pending in the Third Circuit Court of Appeals, in which plaintiffs have asked whether the PA state law for negligent design and strict liability claims related to medical devices are in fact, if that is an actual thing that can happen in Pennsylvania. For those of us who practice in Pennsylvania, we've consistently taken a stance that strict liability claims cannot be filed against medical device manufacturers, but the plaintiffs in the Ebert versus Bart case have appealed it, and it's going up to the Third Circuit. Right now, the briefing is occurring, and it's thought that the decision is going to be handed down in early 2022. So it's one that would be of interest to anyone who practices in PA. So you should keep that on your radar. So I'm going to pass it along now to, I think, Andy is the next presenter.
Thanks, Megan. So I'm going to talk to you about significant decisions and verdicts from 2021. And I'm going to cover numerous things and probably not a lot of time. So if I don't get to all the points on the slide, they will be uploaded. I think Heather mentioned this. They're going to be online eventually, so you can take a closer look, or I'm always happy to answer questions. So Scott, if you can advance to the next slide, please. So there are three pretty significant opioid decisions that we've had in the last about month or two. They kind of came back to back to back. So I need to spend a couple of minutes talking about those. Two of them are good for the defense side. One is not. So I'll start with the good and then get to the bad. The good is the first result we got here was out of California. There was a month-long bench trial against 4 manufacturers brought by essentially some of the largest jurisdictions in California. So LA, the city of Oakland, Orange County, Santa Clara. The trial resulted in a ruling from the judge because it wasn't a jury trial. He ruled in favor of the defendants on causation grounds. He said that the plaintiffs in that case didn't produce evidence of medically inappropriate prescriptions, and that the false advertising that they were alleging there essentially was insufficient to prove that whatever advertising they were doing led to medically inappropriate prescriptions that led to the damages they were seeking. And so essentially there's no public nuisance there. What was sort of interesting there is he also relied on medically appropriate prescriptions couldn't cause this harm, this public nuisance, because the FDA made a determination that the medically appropriate prescriptions, the benefits outweighed the risks, so to speak. So next slide, Scott. About a week after that, we had a decision from the Oklahoma Supreme Court. Many of you may remember back in 2019 that a trial judge in Oklahoma awarded $465 million against J&J on behalf of the state of Oklahoma, claiming that J&J contributed to the opioid epidemic in that state and caused a public nuisance. The Oklahoma Supreme Court disagreed and wrote a pretty well-reasoned, concise opinion that said that Oklahoma's public nuisance law did not cover this type of harm, right? The public nuisance law in Oklahoma is intended to handle discrete localized problems, not these larger public policy problems, and that the Supreme Court wasn't going to expand the doctrine to include something like this. Many other opioid cases hinge on public nuisance. So this decision, which is really the first appellate decision we've had on this issue, it's the first one out there, and I think people on the defense side of this are hopeful that this will kind of gain some steam when other appellate courts start taking up these issues on public nuisance, which is essentially the cause of action that the plaintiffs are using to advance these cases at this point. So Scott, if you can move the slides again, please. The last decision comes out of the opioidMDL, the federal court MDL in Ohio. The first trial occurred there. This decision came out just recently within the last couple of weeks. 2 northern Ohio counties went to trial against CVS, Walgreens, and Walmart. This is these are the big pharmacy defendants in the MDL, and the jury found that these companies created a public nuisance through their role in filling prescriptions in those counties. The damages weren't decided. That issue has been given to, or Judge Bolster has essentially given that issue to himself, and he's going to have a separate damages trial in April or May of next year. This is the first opioid MDL trial, so it's going to be interesting to see what happens in the subsequent bellwethers, which are going to start going to trial. If you can hit the next slide, Scott, please. All right, so there's probably an audible groan for most people when you see that my next slide is about personal jurisdiction, because that's an issue even lawyers don't find particularly interesting. But we had an important decision come out this year from the U.S. Supreme Court. Some of you who have attended this webinar over the years probably remember we talked about the BMS decision, which was a big decision in terms of personal jurisdiction and requiring there to be a connection between the form and the parties. And this was a big blow to the form shopping that plaintiffs' attorneys were doing and bringing tons and tons of claims in these judicial hellholes that had no relation to the form. So kind of after that decision, you know, the defense bar continued to raise this issue, and we have subsequent opinions. And this Ford Motor Company made its way up to the U.S. Supreme Court, and the U.S. Supreme Court kind of said, well, maybe not quite as broad as you all want to apply it, you know. So here's what we're going to say. Defendants don't have to have a specific connection related to this particular cause of action. The connection doesn't have to be related to the form, right? So Ford is the defendant in this case. So the fact that Ford markets, advertises, sells cars, et cetera, in Montana where this case arose, that's sufficient to give them personal jurisdiction, give them a presence in a state, even if there's no particular facts related to this case that are in Montana, right? So if the car wasn't sold in Montana, the plaintiff wasn't marketed to in Montana, et cetera. So I think what we're going to see coming up in the next couple of years are additional decisions trying to reconcile BMS and Ford, because BMS kind of was the pro-defendant's case, and then the Supreme Court just a couple of years later comes back with Ford, and that's the more plaintiff-friendly decision. So I think there's going to try to be some synthesizing of those two decisions. Next slide, please. So Amazon is probably an issue that many people are interested in terms of whether Amazon can be held liable for defective third-party products, because it kind of has some spiraling effects with our with Medmarc's insureds. So there are two decisions that came out this year about whether Amazon can be held liable for their fulfilled by Amazon products, and so that is essentially manufacturer ships its product to Amazon's warehouse. Amazon gets an order, they put it in a box, Amazon delivers it to you. In that situation, can Amazon be sued for product liability for these third-party products? Just briefly, California said yes, they can. The Supreme Court declined to hear that case. Texas said no, they can't, and that they're not a seller under Texas's Products Liability Act. So we kind of have a conflict in the decisions across two very large states. More recently, the CPSC, the Consumer Product Safety Commission, they filed an administrative complaint that's trying to hold Amazon accountable for third-party products sold in this fulfilled by Amazon platform. And even more recently, Amazon said, we'll pay up to $1,000 for injuries or property damage claims coming out of this fulfilled by Amazon program, and that they believe this covers about 80% of the claims made against it. This seems to be kind of a proactive move by Amazon to forestall where the case law could eventually be going on this issue. Next slide, please. So one other issue we've talked about a decent amount here is talc. Over the years, there's another large verdict, the $1 billion verdict that we discussed at least a year or two ago has been upheld on appeal. What's probably more significant than the continuing big verdicts here is J&J has formed a subsidiary, put their talc liability in that subsidiary, and then it declared bankruptcy. So this is a fairly sophisticated legal move for J&J to try to unload its talc liability. As you might expect, the plaintiffs' bar and other people are a little unhappy with this move, and they're planning to oppose this in the bankruptcy process. So I expect we're going to hear more about this in the next year or two in terms of whether J&J is able to unload its talc liability here. Next slide. All right, so there was a significant decision out of the surgical warmer MDL. This is an MDL against 3M and its bear hugger forced air warming device product. The allegation there is that the product causes bacterial infections. This is a device used to prevent hypothermia during mostly orthopedic surgeries. The trial judge in Minnesota who originally heard the case struck the plaintiff's experts on causation grounds, or really struck them on grounds that the evidence that these experts were using to reach their opinions was not sufficient to support those opinions. The case went up to the 8th Circuit. The 8th Circuit said these experts have problems, but not so much that you were justified in excluding them. So now this is back down into the MDL and state court, I'm sorry, in the trial court, and it's going to proceed forward. There's been one bellwether trial here, which was a defense verdict. Next slide, please. So I included this in part because we don't typically talk about property damage cases, and there's kind of a somewhat scary effect of this. So this is essentially a really high-end freezer used to store harvested eggs and embryos. It failed. The 5 plaintiffs, so people who had embryos and eggs stored in this freezer, sued the manufacturer. There was a roughly $15 million jury verdict. There were post-trial motions. The judge said, I'm going to deny these motions. And what was kind of interesting to me is the judge cited the trauma and anguish that these plaintiffs suffered in justifying the amount of the award. So that's a little bit of a scary proposition in that you typically don't see this mental anguish component used in property damage situations. Next slide, please. So this is the last one slide that I have. There was a $21 million verdict in a metal-on-metal hip implant case this year. I mentioned that primarily to tell you all that these metal-on-metal cases continue and that there's continuing to be some bigger verdicts in these. So that's all I had. I'll turn it back to Scott.
Thank you, Andy. And we will move to Karen now for a brief update on some regulatory issues.
Thank you. And I only have a couple updates for everybody, so we are almost done. First update is, again, I had very timely topics. I had very new case law, and I have a update for you as of kind of yesterday on the the FDA commissioner, the recent pick, Dr. Rob Khalif. He had his help committee confirmation hearing yesterday. And if some of you are unaware, there's been no commissioner in place since, no permanent commissioner in place since January. And a lot of the, there's been a lot of criticism for the fact that there hasn't been somebody directing, of course, the COVID-19 relief, emergency preparedness programs. Dr. Rob Khalif actually has previously served as a commissioner. He was appointed originally under Obama from February 2016 to January 2017. His criticism before, the widely held opinion about Dr. Khalif is that he was too lax during his tenure on the approval of opioids, on, and in fact, that was criticism that kind of was coming out while he was serving as the commissioner, and he developed more kind of strict labeling, FDA regulations, trying to combat that. There's also criticism, now since leaving as in 2017, he's had strong ties to both the life science industry, the pharmaceutical companies, and so there has been criticism that he's too closely intertwined with the industries that he will be, he intends to regulate. that being said, his prior, during his prior tenure, he was, an individual that was, worked to kind of help those in the life science and pharmaceutical industries get things to market. He, in his hearing, his committee hearing yesterday, he kind of outlined 3 things that he planned to do. If he's approved, he said he would shore up emergency preparedness, that he was focused on modernizing and reforming the FDA, but that was kind of unclear as to what he really meant, and that he would focus on patient and consumer protection. That, that being said, when he was questioned about the relabeling of opioids, whether he thought that Biogen approval was too quick. That's the new Alzheimer's medication that's come under a lot of criticism for being allowed to go to market as quickly as it did. He said he would develop a better system for evaluating medicine once it was on market, but that he didn't give a clear answer that there needed to be increased strict regulations with respect to labeling of pharmaceuticals. He also interestingly said that he supports Medicare negotiating directly with the industry, the pharmaceutical industries, on pricing, and that he didn't give clear guidance that he would be doing much in the way of adding more regulatory components or hurdles to pharmaceutical or life science industries. So his official confirmation vote will take place in January, and we can expect, based on kind of the questioning yesterday and the letters that were a recommendation that were filed by HELP committee members, it seems as if there's bipartisan support for confirming him, and there doesn't seem to be a concern that he would be blocked in any way. Next slide, please. My final update in the regulatory component has to do with the FDA recently publishing its draft for the new content of pre-market submissions for device software functions. The draft was put out there November 2021. Comments are being taken until February 2nd of 2022. This will be the first time since 2005 that the FDA is updating the recommendations. These pertain to the software, both the SciMed and the SMIMD and SAMD regulations, and particularly pertains to what is required in the way of documentation for these the software in the medical device, the software in medical device and software as medical device. There are a number of changes. I'm just going to kind of focus on kind of the big picture since we're running out of time. The takeaways really are that the changes to it are allowing for manufacturers in certain categories to, instead of the 2005 kind of erred on the side of focusing the shift on establishing expectations for the entire system based on the highest level of risk that these types of devices or the software and these types of classes of devices could present. Now it is changing it in a way where it's separating out the levels with respect to documentation. It's changing to the basic or enhanced level of documentation is a kind of a big difference here. The FDA's categorization of software levels of concerns always was conflicted with the safety classifications, the safety A, B, or C that were described in ANSI and others. So this kind of clears that up and allows for clarity specifying when enhanced documentation is required. There's kind of 4 specific categories. One's a catch-all, but categories of blood products or device components in class 3 devices. There is a catch-all that still says enhanced documentation would be required for those that present a probable risk of death or serious injury. And that may still kind of cause some companies to continue to need to do this enhanced level and can't do the basic, but class 1 and class 2 manufacturers that aren't working in combination with those specific products that are outlined or the blood related devices, they may be able to segregate out their low risk functions from their high risk functions and do basic documentation with respect to some of that. The other change here that will impact the life science industry is the device hazard analysis has been replaced. Typically before the manufacturers were permitted to just submit the risk analysis and they didn't have to submit the complete risk file. Now they're proposing a risk of the complete risk file. Again, this shouldn't have a terrible impact. I mean, from a documentation standpoint, attorneys were assisting life science industry companies with preparing that risk analysis, and they were generating, gathering all of the information in the risk management plan and the risk assessment. They just weren't submitting the entire thing. This will require submission of the entire thing. So in that respect, it may require companies to work more closely with attorneys when submitting all of this documentation, but this was already being done. This was already how things were happening as well. The final kind of thing I just noted here was they're now allowing for declaration of conformity with the IEC 62304 instead of needing to demonstrate that the that's the, for those that don't know, that's the standards that govern software lifecycle process functional safety standards. So now they could just issue a declaration when before it was kind of needed to list all the activities and tasks that were demonstrating conformity with that. So again, the kind of bigger picture of things that we're seeing in the regulatory space is there's more structured documentation with respect to some of these pre-market submissions, but certain manufacturers are going to be able to more clearly fall within that basic level of documentation, and the documentation categories are being simplified. So the categories are more simplified, but there may be more required within each. So we can kind of recommend that the companies continue to work in developing the comprehensive risk management files, so that they when needed for the enhanced level, they're able to comply with these. If these are passed, if these new revisions are passed, and they can comply with those new requirements.
Thank you very much, Karen. Well, at this point in time, I wanted to open the floor to our panelists and get an idea as to what you think we'll be talking about this time next year.
I can take the lead or answer that first, Scott. This is Andy. Now, you'll be surprised to hear me say this after I already talked to you guys about opioids, but I think I or anybody else you talk to will still be talking about opioids next year. There's a number of cases that are in trial right now, the biggest of which is the New York State trial, which has been pending for a number of months. I believe closing arguments were last week. So we should get a decision out of that jury trial soon. There's a trial pending right now in the state of Washington. So there's a number of decisions coming in the near term. And I think maybe we'll start to get a better consensus or better idea of what's really going on and kind of the direction that these cases are taking, and what the next steps are going to be. There's always various news articles about settlement discussions and kind of one-off settlements. So I think that that's something that'll continue to remain in the news as well.
Anyone else have anything to share?
I can chime in, this Karen Shimonsky, just on the couple topics I talked about. With the PrEP Act, we really haven't seen a lot of litigation in the last 6 months interpreting these ideas of preemption or of complete preemption or the kind of weight that should be afforded to the Secretary of Health and Human Services with respect to life science industry defendants. That's likely because they're continuing to it's clear with respect to those defendants where exclusive jurisdiction lies. But I would encourage everybody to continue to keep up with the PrEP Act litigation or rulings that are coming out to see if there are any guidances given as to that willful misconduct definition of what's meeting that, since life science industry defendants are still subject to federal jurisdiction in those that category of cases. So I would encourage everyone to see if there are any cases that are applying this heightened standard of saying that punitive damage claims don't count, or really defining what that might be with respect to specific life science industry clients or defendants. And then I also we've got a couple things coming up with the seeing if the pre-market submission draft goes into effect next year, and also seeing if this commissioner is approved in January. So those are two big changes that'll have some impact on the regulatory component for drug and device manufacturers. So keep up with those next year as well.
Hi, so this is Lauren for one last comment. I think one of the things that we're going to start to hear a lot about is called the Internet of Medical Things. A lot of our devices are connected, and just like we have the Internet of Things, which is everything online that's then interconnected to the cloud, I think we're going to start seeing developments and technologies, and unfortunately then later claims associated with these wearable devices that are becoming more prevalent in society.
Thank you very much, everyone. If you need to reach any of us, our information is on the screen at this point in time.
All right. Well, Megan, Karen, Andy, Lauren, Scott, thank you all very much for your time today. This is such a useful topic for our audience, and we really appreciate your sharing your expertise and presenting such a comprehensive look at the state of litigation today. Thank you for joining us. This concludes today's webinar.